House Bill 349 is legislation to amend the PA Construction Code to require that municipalities which opt in to enforce the Uniform Construction Code by utilizing third-party agencies have at least two or more under contract to administer the code. The legislation has been well vetted. A hearing was held on this legislation, which formerly was House Bill 782, May 7th in 2015, before this committee, and then a previous version of this bill, House Bill 1469, actually passed the House last session and was amended and then passed in the Senate, only to run out of time before we could concur in the House to send it to the governor's desk. So the bill as presented right now is as it was amended with the language in the Senate. It was agreed to and passed in the Senate. And 90% of Pennsylvania's 2,562 municipalities have elected to administer and enforce the UCC code locally using their own employees, joint administration, or via certified third-party agencies, which are private code enforcement for-profit companies. That it is estimated that about 60% of the opted municipalities have chosen to administer the code by contracting with third-party agencies, with a clear majority of that 60% using just one third-party agency. The primary arguments that municipalities use to rationalize contracting with one third-party agency is that they can hold the agency accountable for administering the program. And they also argue that competition will lead to some agencies compromising their enforcement standards to obtain business. I have argued and continue to argue that all third-party agencies are certified by the Department of Labor and Industry and thus are legally required to enforce the standards of the code. In fact, there are many areas of the state where municipalities allow property owners the choice of multiple third-party agencies, and there have been no issues. I think it is also important to note that the same TPAs that are here today arguing that choice will weaken the standards also compete and work in those opt-out communities, and they enforce the code to the same standard whether they are the lone third-party monopoly or whether they are competing. My legislation simply requires that municipalities with third-party agency monopolies contract with another third-party agency to provide some choice for property owners. Agreements between municipalities and third-party agencies are considered professional services under law and not subject to competitive bidding. I argue that requirements for a second third-party agency is not a burdensome mandate, and I believe there are some ample third-party agencies in the state that would be willing to offer their services as a second third-party agency. The legislation provides a means for very rural municipalities that cannot find a second third-party agency to apply for a waiver through the department. It's important to note that my legislation has no effect on municipalities that have their own indigenous code enforcement. So if they have their own municipal employee that enforces a code, such as Philadelphia or Pittsburgh, this legislation does not deal with them at all. And I'd just like to take a couple of minutes to just explain a couple of scenarios and why this was brought to my attention. Certainly when we run for office, we talk about taxes and all the other things, but not necessarily third-party agencies. This is a burdensome mandate that we have placed on small businesses throughout the Commonwealth to have to work with just one monopoly. I had a project in the district, and a gentleman, I asked him to send me a quick note, and he told of how a code enforcement officer threatened his business by overzealous application of the new building code to an existing business. Over a year, the township and their solicitors fought a dictatorial interpretation of this code by a monopoly-authorized inspector. In the end, after consuming massive legal fees and the consumption of taxpayer dollars churning in the system, the officer conceded at the final appeal hearing that he admitted the application of the existing code on an existing building would be more appropriate. In the end, the question of whether to fight or to churn the money from the community or be able to choose an inspector who's going to enforce the code to the state standards and not their own standards has cost this small business the opportunity to grow in the community. Is that a warning or 30 seconds? All right. We also had the opportunity for a distillery to come in our area, and this was by another third-party TPA that wanted to enforce the code to a higher standard than what the state code is. And all we're looking for is uniformity and the opportunity for recourse. So if you have a history with one particular inspection agency, the next time you do a building project, you can choose another one. This bill, if you hire one third-party agency, this bill will require that you use that agency for the all your inspections for that project. So you can't just switch out halfway through the project. But it would allow choice and opportunity, and therefore would increase opportunities for economic development across the state.
All right, thank you, Representative Heffley. Do we have any questions for Representative Heffley at this point? Representative Nelson?
Thank you, Mr. Chairman, and I appreciate your efforts, multi-year efforts, at this issue, which does carry a good bit of controversy. In my area, there's a lot of passion in the construction world. It's fast-paced, and there's also conflict. So can you expand a little bit more on the importance of a builder that may have a conflict history with a certain inspector, how that could impact their project, whether they, the pouring of a form or getting final approval? Because that the option of choice in going with someone seems to be something, at least in our area, that our builders would like the choice.
Yeah, originally the legislation we had authored was to expand it that you could contract with any state licensed third-party inspection agency for your inspection, similar to what we do with automobile inspections. It would be absurd to think that a municipality was going to pick one service station in each township or municipality to say everybody has to take their car there for a state inspection. That's as absurd as it is for that concept. That's how absurd this concept is. So what happens is maybe you do have a history with somebody. It could be a family history. It could be just work history. Maybe the person worked for you and no longer does. But when you have a monopoly, and they could just delay the inspection process. You have a whole crew there ready to pour forms, and they have to come out and inspect beforehand. There's been history of folks that just never showed up. So they had to pay the crew for the whole day to sit there and never got to pour their concrete. There's also been instances where people just don't like a particular business in their community, but they're a legal business in their community, and they're set up to run that way. And townships could use that as a tool to hinder economic development and growth in those areas. But I think monopolies are always bad, and forcing somebody to use somebody that they don't want to, especially when these are third-party, for-profit companies and these contracts are not put out to bid. I think it's really obviously. This was brought to my attention by folks in the community that were struggling to get their projects completed, and they want to businesses want to follow the code and make sure the code is applied correctly, but they don't want people to misinterpret the code and cost them extra dollars.
Thank you, Mr. Chairman.
And we're going to try to limit the questions at this point. I'll allow one additional question.
I'll kind of make my answers quicker.
Thank you,
over
Mr.
5 minutes there.
Representative
I'll
Kruger.
be quick, Mr. Chairman. Thank you for joining us here today. I was just looking at the bill history, and I voted no on this bill last session on the floor because I had some concerns about the impact of this new regulation on our local municipalities, including the folks I represent in Delaware County. Can you tell us how has this bill changed since last session? I know that there was mention of an amendment in the Senate.
Yeah, what we had passed in the House last session would have allowed for any municipality. It wouldn't have been no mandate. Actually, the municipality would have done everything that they always did. They could contract with one, but the builder or contractor or homeowner could then use their own state licensed third-party agency and pay an additional fee to the township. So that was changed in the Senate, and it was amended to apply that municipalities must contract with two or more. Right now, it's one or more. They have the option to contract with two or more, three or more, four or more, or five or more, and many municipalities already do that, and there are no issues. So to say that this is a mandate is not accurate because municipalities don't have to opt in. They can just allow it in 10% of municipalities across the state. They opted out. L&I enforces the code, so there is no mandate. So the argument of a mandate on municipalities is incorrect because they don't have to do anything. They could opt out and just have those builders in that area have any state licensed inspection agency do the inspection.